Okay, so my first question would be what do you think about the interrelation between the fundamental social rights and the other types of rights? What's the relationship between a hierarchical relation or?
Yes, we've seen an evolution there because for a long time, fundamental social rights were seen as a special category of human rights or fundamental rights. Not so much, I think, because of their subject matter, but because of the type of state obligations that they require, because it was thought that the traditional human rights, like freedom of expression, for example, or freedom of association, only required from the state non-interference, abstaining from interfering with those rights of individuals. Whereas with social rights, the idea was that the state had a positive duty to help the realization of those rights, sometimes by funding them, for example, the right to education or the right to health. And because of that, the international social rights, and also at the national level, were kept a little bit separate, as being less justiciable, less capable of being enforced by courts in individual cases, and more things that had to be realized gradually within the availability of resources. So that was the traditional view, I would say. But gradually, I think the idea became shared first among international human rights lawyers, but now also more gradually in legal instruments, that you cannot really divide these categories neatly, because some social rights also do not require state activity. For example, the right to strike is something that workers can do. They don't need the support of the state to do so. So why is that different from another right? No? And also, every fundamental right requires some support from the state. So that distinction isn't so neat between the two. And so gradually there's been this recognition of what is called the indivisibility of human rights and of fundamental rights, that all categories are equally important. And so you could say that the position of fundamental social rights has been upgraded in international human rights instruments, but also in national constitutions. So what we see in Europe is that whereas references to fundamental social rights were almost exceptional for a long time, now most constitutions of European countries, including that of Turkey, has a large number of social rights included in their constitution, alongside the traditional human rights. So there is an emphasis on indivisibility.
Okay, thank you. And second question is the following. Do you think that the protection of fundamental rights is easier to achieve on a domestic level when compared to international mechanisms?
Mm-hmm. Well, the basic level is the national level, because that's the level in which the actual rights of individuals have to be guaranteed. For instance, if we talk about the right to education or the right to housing, to typically social rights, they have to be ensured at the national or even at the local level. They cannot be ensured directly by international institutions. So the role of international institutions is a subsidiary role, is to help the countries to achieve those rights by putting pressure on them. And this kind of pressure can be of different kinds. If we think of the Convention of Human Rights, which also has some social rights, there the pressure can be an actual judgment of the Court of Human Rights declaring that a country has breached the convention and must take the necessary steps to remedy that. So that's very direct legal pressure. Sometimes it's a bit more diffuse. It can be a general comment by the international human rights body, or it can be, for example, in the case of accession of new countries to the European Union, the European Union can try to convince those countries to take on board the guarantee of certain new rights. So there are all sorts of ways in which the international level pushes the countries to improve their record in the protection of fundamental social rights. But the actual achievement, the actual implementation happens at national level. So that's the most important level.
Yes. Okay, thank you. And what do you think about different models regarding constitutional protection of human rights?
Like models of judicial enforcement?
Like the category of human rights in some constitutions, or for instance, now we will have the ombudsman, and we will have the individual application to constitution.
Yes. Okay. So you can distinguish models in terms of the kinds of rights that are protected, And there, as I said before, you tend to have a diffusion of the idea that social rights should be included in the constitutional protection of rights. But there are still exceptions. For example, the United Kingdom has the Human Rights Act, which is basically the rights of the European Convention of Human Rights and very few social rights. So there they still make the distinction. But in most countries, in terms of the categories of rights are protected, social rights are there alongside the others. Now, in terms of the institutional mechanisms for the implementation of rights, there we have big differences between countries. And so in Turkey, you have just introduced the individual complaint before the Constitutional Court. That's a big difference between some countries that have that. Germany has had that for a long time, but also Spain and Belgium and so on. And then countries where that is not possible, where the Constitutional Court can only deal with such cases if they have been referred to by an ordinary court in the course of a dispute. Then an ordinary court can say, oh, here there may be an issue of fundamental rights protection. We will ask the Constitutional Court. So indirect review only. Then you have the role of other bodies. You mentioned the Ombudsman, which in some countries has a very active role in the protection of fundamental rights. You also have agencies or bodies, for example, in the field of equality, non-discrimination. Every European Union country now has had to put in place what is called an equality body, that is to say a public agency that has a special task of making sure that non-discrimination is being prevented and combated in a non-judicial way. So these instruments are also very important. One should not focus exclusively on the role of courts, I think.
Yes. What do you think about the future of the social state in Europe? Do you believe that things going to improve, or?
Yes. So this, again, I cannot judge on the state of play in Turkey, but if I look at, let's say, Western Europe or the EU countries that I know a bit better, there certainly the social state is under pressure because the welfare state is very developed, very well developed, so it's a large percentage of state expenditure for welfare services. And because of the cutbacks in state budgets, which you see in many European countries, also with the Euro crisis, we see that these programs are being targeted. So there's a tendency to reduce pensions, for example, or to reduce social assistance, or to increase tuition fees in education and things like that. So the achievements of the social state that have been gradually built over the past decades are now put under pressure. But I don't see a sort of an overall calling into question of it. So I think that in most European countries there is an effort to preserve at least the essential features of the welfare state. It's seen as an essential characteristic of European democracies, you could say. If you want to contrast that with North America, with the United States, for example, European countries pride themselves on a much more developed welfare state and want to keep that. But they are under financial pressure, so they have to be inventive in finding new forms of social protection and in saving money, perhaps in requiring people to work longer, so as to reduce the cost of pensions and things like that. So there is a rethinking going on, but I don't think that we see a complete demise or a complete disappearance of the social welfare state. I think that European countries will want to preserve that in the years to come. And it's one of the roles of the European Union and of the human rights bodies of the Council of Europe to help the states in doing that by emphasizing the importance of fundamental social rights.
Okay. And do you agree with the statement that a more comprehensive protection is employed with regard to social rights as of the entry into force of the Lisbon Treaty?
Mm-hmm. Yes. So the Lisbon Treaty, which has revised the existing treaties of the European Union, has made some changes. So the most important one in this respect is the fact that the EU Charter of Rights, which is the Bill of Rights of the EU itself, has now binding legal force through the Lisbon Treaty. So it's part of the constitutional law of the EU. But also, apart from the Charter, you have a number of new references in the treaty to the importance of social rights and social protection. There is a so-called horizontal clause, which is a clause saying that in all its activities, the European Union should take into account the need to preserve social protection and to combat social exclusion, for example, and to combat discriminations. So it's now become much more an overall duty for the EU institutions to do so. So at the level of the texts, at least, I think there is an improvement there. At the level of the implementation, we're still waiting to see whether this new message is going to be internalized by the EU institutions. They're now much more obsessed or occupied by the euro crisis and economic competitiveness. These are now the main issues on the agenda, and so certainly the social protection agenda is a bit neglected for the time being. So we still have to see whether the new treaty language, which is positive in terms of fundamental social rights, will also be translated into reality.
Yes. And like having talked about the internalization of the protections that are brought by the Lisbon Treaty, I would like to jump on another issue which regards the discriminatory mentality throughout Europe, and also xenophobia that has been argued that has increased throughout the years, like recently. So do you agree with this? Do you agree with the statement that there's an increase in the xenophobia throughout Europe, and do you think that the non-discrimination regulations would be enough to mitigate this problem? Or if not, like what could be the other enhancements that could be implemented?
Okay, that's a very difficult question, of course. Because it's true that if you look at the law again, then there is the instruments to combat discrimination are more numerous than before. So you have a number of directives of the European Union to combat discrimination. For example, a directive on racial discrimination that prohibits racial discrimination, for example, also in private services. So, for example, for people renting out their property, or in private schools or whatever. So in all those areas, there's now Europe-wide, at least within the European Union, prohibition on race discrimination and ethnic discrimination. But at the same time, as you say, these practices continue to exist, perhaps more than before. It's difficult really to know that, but certainly they haven't disappeared. And so there's two questions there. Are these legal instruments potentially effective? Are they really the right ways of tackling the problem? And if they are they actually implemented correctly in the member states? So there we have the role of these equality bodies that I mentioned before. So equality bodies are there to try to promote also a culture of equality, of non-discrimination in a population. They're not just about remedying individual cases, they try to change mentalities. That's a long-term process, and some people are pessimistic, saying, well, we're going in the other direction because of, economic difficulties in many European countries. There's a phenomenon of scapegoating taking place. So who is responsible for problems? It's the outsiders, no? It's the ones, the migrants or the minorities, they're the ones who are responsible for our problems, and therefore there can be actually an increase of discriminatory attitudes. So we're going in both directions, I think, in the level of legal documents, but also in the sort of living reality of the law. Discriminatory attitudes and activities are being sanctioned, are being sort of fought more effectively than before. In terms of mentalities, it's a much more long-term process, and there it's difficult to see where we're going. So it's a combat which has to be continued. So it's not enough to change the law; it has to work on the mentalities.
Yeah, unfortunately enough. Okay, thank you so much for this. And so you worked on the linguistic diversity and the language rights a lot. So I wanted to ask you, like, how can the linguistic diversity and the protection of language rights as cultural rights be secured in the best way? And what is done within the European law context with this regard?
Yes. Again, I mean, language rights are being dealt with in constitutional law of single countries, but also at the European level, for example, the European Convention of Human Rights, and also in EU law to some extent. If you look at the European Convention of Human Rights, it doesn't talk much about language, but you could argue that if the Convention protects freedom of expression, for example, it must logically mean the freedom to express yourself also in the language of your choice. And that's and the question which, for example, in Turkey was very difficult for many years. There's been much improvement there, but for many years, as you know, Turkish citizens were not free to use the language of their choice, even when writing in an independent newspaper or speaking in public even. So there things have changed. So that's the basic guarantee, I think, that every democratic state must offer to linguistic diversity, is at least people should be free to use their own language, whatever that language is, when they speak to each other or when they want to communicate their ideas to others. The next stage, and that's more difficult, is the use of language by public authorities. Because as soon as you are in a public law situation, for example in public schools or in dealing with public administration or in courts, there is of course it's not just a matter of allowing people to use their language. You have to make sure that the state or the public authorities also communicate in that same language. So there you are imposing actually a duty on the state. And that's more costly. And it's also logical that a state cannot function in 100 languages. So choices have to be made. Choices about which languages are official in a country and which other languages, minority languages, can also be used in certain circumstances. And there, the tendency in Europe, I would say, is to give growing recognition to minority languages if they have a regional territorial basis. So there's not much recognition, I would say, of the official use of migrants' languages, because they are supposed to adapt themselves, to integrate. But when we speak about traditional regional language groups, take for example in Spain, Catalan and Basque, for example, but in Turkey it could be Kurdish. There is a tendency across the board in Europe to give greater recognition to the public use also of minority languages if they have sufficient numbers. No? So that local authorities should be able to function in those languages, that teaching should be provided in public schools in those languages. So there's a whole battle going on about that, and a lot of pressure has been put here, I think, that by European institutions on Turkey to improve its record on this point.
Yes. My last question will be with this regard, actually. You made a distinction between the language of the migrants and the language of the people that are already dwelling within a region. Like, and as an example, we can give the Kurdish people. And now there is a hot debate going on in Turkey, as you may well know, that Kurdish people claim to defend themselves in their mother tongue in court. So, to which extent do you think the language rights should allow this?
To defend oneself in a criminal case in the language, in one's own language?
In his or her mother tongue. And the criticism is this. Yes, you might be ethnically Kurdish, but on the other hand, you have been living in Turkey since you were born, so you also speak the Turkish language. Yes. So here they see some bad intentions. And they say, if you know Turkish too, why do you want to defend yourself in Kurdish? And of course there is this economic aspect of this judicial economy. So where can we draw the line here?
Okay. Yeah, that's an interesting question. If you approach the issue from the perspective of the right to a fair trial, which is the way in which the European Convention deals with that, then you could say you have to allow a defendant in a criminal case to defend him or herself in a language which he masters. So if a defendant would not be able to speak Turkish, then under this idea of fair trial, that person should be able to speak, let's say, Kurdish with translation. But this is not the case in here, because all Kurdish people also speak Turkish. So from the fair trial perspective is not the right one here. The perspective to look at these cases seems to be one of linguistic equality. That is to say that in areas in which the minority language is widely spoken, which would in the case of Turkey be the provinces of the southeast, it seems fair to say that the language which is widely spoken, regional language, should be used by the courts alongside the official state language, which is Kurdish. And that is the solution which has been adopted in many European countries, where you have a local language which is spoken by a vast part of the population, then the courts are bilingual, basically. So that, I think, would be the approach in Turkey, meaning that in some areas of the country, from that perspective, the right choice would be to make the judicial system bilingual, but be able to function both in Turkish and Kurdish, but not in the whole country necessarily. So that if a Kurdish person would be involved in a criminal case in Ankara, for example, that wouldn't mean that he then would be able to use Kurdish because it's not a locally spoken language then.
Okay.
So that would be my approach to this issue.
Okay. Okay. Thank you so much for your answers.
You're welcome.
Thanks a lot. It's very nice.